Our first speaker today is Harshvardhan Pandit, who is going to talk to us about semantic interoperability of legal compliance from GDPR to data spaces. So let me hand over the floor, Harsh, to you. We look forward to hearing about it.
Hi, so I'm Harsh. I'm an assistant professor at Adapt Center School of Computing in DCU, and I'm going to be talking about data spaces, which, as we just heard, is a very hot topic. But then, before we kind of get there, we have to understand what is the legal regime in which the data spaces are placed in. So, EU is currently building an entire repertoire of data spaces, or or rather, different data spaces, which all have their own corresponding laws. So if we want to deal with personal data, that's GDPR. If we want to deal with digital services, digital markets, different kinds of data, then the DSA, DMA, DGA come into play. If we want to use AI, then the AI Act is going to affect. So how is this supposed to work? Are we building a jigsaw set of laws where they're all supposed to fit into one correct, harmonious solution? Or is the reality more like Lego, where we have many different solutions, but we need to figure out what the pieces are and how do we build it? So looking at the current challenges, which is what we have for GDPR, in the past 4 years, we have lots of good stuff coming into in terms of how such laws can work, such laws can provide innovation, such laws can prevent risks and harms. But then we have also identified lots of challenges in terms of the time. It's very expensive to figure out how compliance should be. It's even more expensive to figure out how to investigate. There are certain gaps and loopholes. Different spaces have different jurisdictions, different domains. Then we have the need for consistency. So we have EDPB, but even then we see a lot of challenges. This costs money, and this brings into question that can such laws really work at web scale, where the amount of data is vast? And when we start getting into data spaces, all of these challenges are only going to increase, which means that what is already limited in terms of how new technologies work, how do we gain the knowledge of how the law applies to the use cases, and specific side effects, such as those pesky pop-up dialogues that keep coming up even though there's no law that specifically requires it, are only going to be amplified when we get to something as extreme and ambitious as data spaces. So how do we get from compliance to compliance automation? Data spaces are all about bringing data within the spacious harmony of using technologies to extract more and more value. But in order to do the same for legal compliance, we need three tenets. The first is automation of compliance, which can only be done if the information or the data is machine readable. If you don't have this information in machine readable format, you cannot automate it. Then this information needs to be interoperable. If that information or data model is only specific to one data space, to one organization, to one company, then whatever legal compliance solutions are built will only work for that company, for that data space, for that domain. What we want is interoperable legal compliance that can work across all data spaces, which brings us to another important point that such legal mechanisms have to be consistent. They have to have a shared interpretation of what the law says, and they have to have a shared representation and implementation within specific data spaces. It cannot be the case that one data space has one idea of what consent under GDPR means, and another data space has a completely different idea of what consent should mean. So when all three of these terms and executions work in harmony and work correctly, we go from what is currently a challenge in terms of how to identify and implement compliance to how to automate compliance so that our jobs become easier and the data spaces can work as intended. So the research problem here is how to create effective compliance mechanisms based on proven information management practices and standards. So rather than coming up with some crazy new solutions, we have a vast history consisting of over 200 years in terms of how laws work, what is the legal metadata required, how to create interoperable specifications that work on information. This starts from simple things such as how to convert a handwritten document into a computer, which now we can now use Word and type it out, to putting it in structured and machine readable formats such that we can build automated solutions that validate this information. So they can check whether all the information is there, and then they can check whether the correct information is there, and then they can check whether a specific norm or requirement under some law is fulfilled or not. So rather than focusing directly on compliance, how to make sure consent is given, we should be focusing on conformity. What is the information needed that should be present in those data spaces? How do we ensure that it is always present in the correct format? How do we conform to some known implementation of GDPR, which then becomes the precursor to ensuring compliance? So the focus on documentation and information management also helps legal analysis and authorities who want to see the documentation in their investigations, and also companies who want to make sure this documentation exists so that they have a proof or provenance chain of their own compliance within data space. Based on this idea and thoughts, the Special Hash 2020 project started a community group called Data Privacy Vocabularies and Controls way back in 2016 when GDPR was first published. And then in 2018, the group got together and started work on the data privacy vocabulary, which is a rich set of vocabularies focused on GDPR that provides the who, what, where, why, etc. regarding data processing. So this is a set of taxonomies that helps explain who are the controllers, what kind of purposes is the data being used for, what is the legal basis, what kind of operations happen, who are the recipients. And over time, we have built up this vocabulary to a certain version 1 release, where we now believe it is usable and practical in the real world. I'm happy to announce that this vocabulary is being used by several academic projects as well as industry partners, and that we are only starting to warm up to the idea of such vocabularies being useful in the real world. The future plan includes extending this vocabulary to cover Data Governance Act, e-privacy regulation, AI Act, and whatever more legal norms that come our way in terms of EU and data-related acts. So if you're curious about this, and you should be, please check out the DPV specification and please join the group to help improve this. What does DPV enable? So by providing this concept in machine-readable format, it becomes a semantically rich vocabulary which allows information to be represented and targeted to compliance-related tasks. This means you can have a central information model, a knowledge graph, if you will, and from that, you can generate your privacy policies, you can maintain consent records, you can perform or identify risks and also identify the specific impacts. And all of these things that I've mentioned and are on the screen can be recorded in terms of documentation, can be embedded into tools and software such that you can check whether this information is present, is correct. And you can, of course, do your own impact assessments, have portability, represent things that are organization specific. But the real value here is that there's a shared understanding, a shared semantic, which is very essential for data spaces in terms of information and the data required. So how is this going to work in the future? Well, we have lots and lots of different laws. So rather than focusing on creating a specific solution that works only for GDPR and another specific solution that works only for DSA or the AI Act, it should be in our shared interest to develop something that will work across all of these different laws, such that the solution for DMA or AI Act should also assist with whatever are the existing norms in GDPR. So what we want are modular and simple vocabularies that are focused on specific tasks and operations and obligations in these various regulations. And then using various combinations of these, we can create solutions that can be quick and adaptive to whatever new challenges that come up in terms of case law, in terms of DPA guidelines, in terms of new loopholes, or the other regulations that are coming up. So we also have the Data Act, the specific requirements for health data space, which go beyond what is just the data space, but also the Interoperability Act, which are proposals and which kind of mean that they can change and introduce or reduce the amount of requirements that may come tomorrow. So such modular, simple semantic vocabularies help quickly adapt and quickly build solutions that are not possible when we try and build end-to-end solutions. And that is all from me. If you wish to talk to me more about this, here are my contact details. Thank you.
Harsh, thank you very much for that presentation. It's a complex issue. We all know that it's a very much a moving space. I'm thinking with GDPR, the difficulties around enforcement are, I'm sure, well documented. You're in DCU, you know, in Ireland, there's a particular issues regarding enforcement. But I'm interested to know how the data privacy vocabulary will be maintained over time and updated. How are new terms added to the vocabulary? I'm thinking of things like very large platforms, which we've seen as one of these new definitions, but even something like the e-privacy regulation, which is going to be an evolution of the e-privacy directive, but it's been stalled for so long that we even have new technical terms being incorporated. It's a very big challenge. Tell me how you approach that.
So I will just go back to one of my slides to refer. So these terms come from three primary sources. One is the law itself. So the law uses some term, it defines certain things. So this can be, okay, certain things have to be done in some amount of time. You have some actors that are based on roles, or you have some obligations that are defined very loosely. Then the second bit is the DPA guidelines, which kind of expand upon what the law says in terms of clarifications, in terms of what it means and how it connects to organizational practices. And then the third is whatever is the industry or community specific requirement. So in terms of how consistent and formal these terms are, the legal term takes precedence. DPA guidelines are like a soft definition. So we follow all three of these in this particular order. And to get to this level, we have to talk with computer scientists, with lawyers, with authorities, with sociologists, which is what the group really does. It provides a real community space for these people to get together, to agree, to disagree. And what emerges from this is a term that kind of everyone agrees on.
Well, you've gone some way to asking one of our audience members' next questions, which is who can participate with the work around DPV?
So everyone can, everyone should. But in the long term, and I realize I didn't quite answer your previous question as well, how is this going to be maintained? So the solution to start such efforts is a community group, because you need some stability before you go to the standardization route. So short term, we build up this knowledge using community groups, which are less formal, which can adapt quickly to things. But the moment we think that, okay, we need to take the next step in getting these vocabularies to be used, I think this is where Endorse and SEMIC and ISA2 can really do good by taking up this work and saying, okay, what can we standardize? What can we provide under a semi-official label? So we already have a lot of vocabulary that are coming out of EU and lots of interesting new work. We have European Interoperability Framework. We have the whole GAIA-X initiative. We have the Data Spaces initiative. So rather than there being parallel initiatives, it would be very interesting for SEMIC, for example, to say, here's a core set of vocabularies.
And can I ask you just very briefly to touch on the multilingualism aspect? I'm thinking of things like the European Health Data Space, which we're going to see. Seems like it's going to be complicated and additionally complicated because of multilinguistic considerations.
Yes, I agree. It's a very challenging thing to have multiple consistent linguistic vocabularies. So unfortunately, we did not focus on that, because our objective here is to just get as many concepts in as possible. But one good thing in the EU is that every time we have a law, every time we have some legal document, it is always translated into the official languages. So it's only a question of getting an expert in that language to sit down and identify what is the corresponding term. So it's just a question of time and getting someone to do the work rather than the challenge of researching it. So vocabularies like this, and also the previous couple of presentations where we saw Walkbench and ShowWalk, show that we are ready to provide linguistically rich vocabularies.
Well, thank you very much, Harsh, and thank you for the great work you're doing. It's a really exciting area and one that is rapidly changing. So I don't envy you the hard work you have in the future. So thank you very much again for that and for your presentation.